Okay, so this lecture is going to be about copyright, ethics, and a bunch of different things. A lot of this is going to be covered if you spend some time in your AIGA book or your Graphic Artists Guild handbook. Both of them discuss ethics for illustrators and graphic designers. But I thought I would just, pull out some of those thoughts and extract them for you, and to maybe clarify a few of the things as we go along. Okay? So we're going to start with copyright. Well, actually, let's talk about intellectual property. So intellectual property is a very important topic for creative professionals. We strive to produce work of significant value, and we negotiate with our clients for its use and, of course, its ownership. So what we're going to talk about is an overview of the core issues for design and marketing, which is things like copyright, trademarks. I'm probably not going to spend a lot of time with trade dress, utility patents, and design patents, okay? It also covers, we're going to cover some essentials of trade secrets and some moral rights, okay? And probably end up with some challenges of protecting intellectual property rights, but it all depends upon how long this lecture ends up going, because I don't know how long it's going to go for, okay? All right. Now, the key on being an independent designer or being a separate business is, and I was taught this very, very early on in a business class. It was Business 101 once upon a time, was no, it's not about calling a lawyer. It's about knowing when to call a lawyer. And you don't want to do it too late. And so if you have questions about things, lawyers are generally your best bet, because that's what they do, especially if you talk to copyright lawyers. We don't have a lot in the area because this is the Mid-Valley. But you get up to Portland, Seattle, you get into some of the other business and contract lawyers. Okay, so copyright is a statutory protection granted to original works of authorship. Okay, and you can't see my fingers, but they're going in double quotes, okay? In the United States, copyright has been an important legal issue since the beginning. In 1987, the U.S. Constitution empowered Congress to enact copyright protection. So 3 years later, the Copyright Act of 1790 was laid out, and it set the stage for the administrative procedures for registration and enforcements. Okay, so since this time, U.S. law has gone through several major revisions in order to broaden the scope of copyright, to change the term of copyright protection, and to address new technologies. Okay, the current version of U.S. copyright was passed in 1976 and became effective in 1978. Okay, they did a digital update in 1998, but there has not been a tremendous amount of change in that, even though technologies are moving pretty fast. So we're probably about due for another copyright update. Okay, so copyright doesn't really cover an idea in of itself. It covers the expression of it in a fixed, tangible form. Okay, so the author has an exclusive right to produce or sell the work, distribute copies, display the work publicly, perform the work publicly, or prepare derivative works. Okay, each specific use can be transferred outright or transferred in a more targeted way, which means licensing. A transfer of rights can be either exclusive or non-exclusive. Okay? Any transfer may be terminated after 35 years except for work for hire. Okay? And we're going to talk about work for hire in just a second. Any rights not transferred explicitly remain the property of the owner. When you create something, you copyright it. through the simple act of creation. It is recommended that you date things. It is some people will put the copyright symbol on their stuff, but really, you have copyright when you generate it. Now, do you have the legal resources to take somebody on who violates your copyright? That's the real question. Okay? So it's important to note that copyright ownership is separate from ownership of the physical work. For example, an art collector may purchase a signed original photograph print, but the photographer will retain the rights and retain the originals. Okay, so now we talked about work for hire. What is work for hire? Okay. Work for hire refers to original work made by an employee. Okay, very specific key term there, employee, in which copyright ownership automatically belongs to your employer. Okay, this can refer to original work made by an independent contractor or a design firm in which copyright ownership might automatically belong to the client, but only under certain limited conditions. Okay, so work for hire. We could take Tim Burton as an example. Tim Burton's Nightmare Before Christmas he was going to do that himself, but since he had started the process when he was still working for Disney, Tim Burton's Nightmare Before Christmas became Disney's Tim Burton's Nightmare Before Christmas. So he was technically under work for hire. The same with Frankenweenie. Okay, so if I do design work on school computers when I am being paid by the school owns the work, not me. So I hope that all makes sense to you. Okay. So the original works of authorship, as I stated before, U.S. copyright law protects original works of authorship. So what exactly we're including when we're talking about original works of authorship, okay? Some examples would be published and unpublished fiction and nonfiction, catalogs and advertising copy, drawings, fabric designs, photographs, sculptures, paintings, architectural plans, choreographic works, theater, musical performances, dramatic works such as, like even screenplays, motion pictures captured on film, computer programs including source code and distinctive screen displays, okay? Which is quite an extensive list, but that's still not everything, okay? Copyright protection covers a broad range of creative output, but it's important to note the following works are specifically excluded from protection: titles, names, short phrases, and facts. Anything that is written or created by the U.S. government. This includes anything done by NASA. Utilitarian works. Historically, this category has included typeface designs produced by traditional methods because the alphabet itself can't be copywritten. It is utilitarian. It was only possible to copyright original characters outside the standard alphabet. However, nearly all typefaces are now designed and distributed electronically. Digital fonts are, in fact, software which can be copyrighted. You just can't copyright the alphabet. So there's collective works. In addition to individual works, copyright also protects collective works. Some examples of this are going to be anthologies, encyclopedias, and such. Derivative works. Okay, so a derivative work is a new work of authorship that is based on something earlier, and it contains enough creativity to qualify for its own copyright protection. A big example of that would possibly be the Bible, or books like that. Books that are being translated into another language. That's enough of a change that it deserves its own copyright. Okay? So duration. Now duration is a fairly complicated subject. So copyright protection begins automatically from the moment a work is created in fixed or tangible form. Copyright immediately becomes the property of the author who created the work. Because the law has changed over time, the exact duration of protection will depend on when the work in question was created. So, for older works that were created and published or registered before January 1st, 1978, the initial term was 28 years, which could then be renewed for an additional 47 years, which is a total of 75 years. However, we have the Copyright Term Extension Act of 1998, which allowed a second renewal and added 20 more years, bringing the total to 95. The second renewal was a bit controversial, because it applied to some important works of American pop culture from the 1920s. You can imagine who is responsible for this Extension Act. Disney was almost solely responsible for that Extension Act to protect their original version of Mickey Mouse. Okay. It also covers things like some original Cole Porter musicals and such. Okay. So the Copyright Term Extension Act was subjected to a legal challenge, but it was actually upheld in January of 2003. Okay. So the duration of copyright protection is different for older works that were not published or registered, and for more recent work. So works created before 1 January 1978, but were not published or registered by that date, the works created on or after 1 January 1978 have the following term: a sole author's life plus 70 years. A joint author's life plus 70 years. Or in the case of work for hire, so if you are hired to do it, it's 95 years from publication or 120 years from creation, whichever is shorter. Okay? So, what they're saying is, if the work was created before January 1st, 1978, but it was never published or registered, before that date, and anything after 1 January 1978, it has the 70-year rule. 95 years for work for hire. So at the end of the appropriate term, a work enters the public domain. This means that copyright has expired and the work is available for anyone to use in whatever way they might like. So we'll put this little note of caution on here. If you are working on a project that involves an older literary work, be careful about translations. If the text that you want to use comes from a recent translation, it will be protected by its own copyright. So, copyright notice. The use of a copyright notice on the work is beneficial, but not absolutely required. That's what I'm saying. It does not need to say that. The standard format is the C with a circle, plus the first year of publication and the name of owner. The letter P in a circle is often used for phono records. A general term, well, that's for cassette tapes, CDs, and LPs, so you don't need to worry about that, If the owner licenses the work to someone else, the licensee's name can only be used on the copyright notice if the license is exclusive, So you can mark it with the letter C, put the first year, the year that it was created, and the name of the owner, all right? Copyright registration. This gets a little bit more complicated. So even though formal registration of copyright isn't required, it can be beneficial, and it establishes a public record of the date of creation and the original owner. This can be really important if you have to sue somebody or tell somebody to, send somebody a cease and desist letter. Okay? So the traditional procedure is to visit www.copyright.gov. Okay, now copyright is R-I-G-H-T, not W-R-I-T. Okay, and download the form. They have a form called the VA, which is for visual arts, and you can complete the form and send it to the Copyright Office. So a traditional, a documentation of the work that you are registering. Okay, so 1 copy if unpublished, 2 copies if published, plus a filing fee. Okay, so the fee for this kind of protection is going to be $85 for paper filings, but you can do the online one for a lot less, which is $55. Okay, generally it will take a really long time, generally over a year, to receive any kind of notice from the Copyright Office once they do it, but you can track it on their website. Okay. Copyright infringement. So infringement is unauthorized use of a copyright protected work or making a copy that is substantially similar. It's the opposite of seeking and receiving permission, using correct notice of ownership, and contracting for payment of a royalty or fee. Okay? Acknowledging the source of the original material does not substitute for obtaining permission. A copy is considered to be substantially similar when people can recognize the copying. Okay? This means that small changes do not avoid infringement liability. Copyright infringement must be intentional. The infringer must knowingly copy the work without obtaining authorization. Coincidental similarity does not count on that. So how much does something have to be changed? Well, some will say 30%. Okay, so what does 30% mean? What is 30% of a change? Is it how many Photoshop filters is 30% of a change? Does it still make the photo recognizable? That's really kind of the key. All right. But remember, you can be sued for anything. So whether or not you're protected or not is arbitrary and can be decided by a judge. Okay. So if you become aware that somebody is infringing on your work, you should have an attorney send them a cease and desist letter. Okay, you're not suing them, you're telling them to stop. Okay, it is a legal obligation that you should tell them to stop. Okay, so the next step is an injunction or restraining order to stop them from using it. Okay, and in a lawsuit, you're going to have to prove that you own the work and the defendant had access to it. Okay, which means somehow it was published at some point. You can recover attorney's fees if you win. You can also recover actual damages and statutory damages or the profits generated by the infringement. Okay, it's more often than not, it's more of a patent issue when we're talking about those kinds of things. Okay, so there are copyright fair use rules. Okay, there are certain uses of copyright protected material that does not constitute infringement. For the most part, these are criticism, comment, news reporting, teaching, education, scholarship, and research. Okay, fair use also protects parody and satire and caricature. Okay, all right. Many disputes over fair use arise when copyrighted materials are incorporated into works of fine art. Fine art is generally considered to be fair use because in most cases it is transformative. A transformative work is one that does not duplicate the objective of their original. Instead, the original work is used as raw material placed in a new context and given new meaning. So, Some case that might be protected would be the classic Dada people who tended to do a lot of collage, taking what were technically copyrighted text or images and pasting them in a collage. Once they're in the collage, that's a fair use because they're no longer whatever they were. Okay, so copyright is not a trademark. Trademark is used by a business to distinguish its products or services from those of its competitors. Its purpose is to identify the source of a product or service and prevent confusion in the marketplace. Lots of things can serve as trademarks. They are grouped into two general categories. We have traditional trademarks and non-traditional trademarks. So a traditional trademark can be a word, a letter, a number, a phrase, a design, a shape, or any combination thereof. Non-traditional trademarks can be a color, a smell, a sound, and a motion design. Okay? So what that means would be like animated versions of a logo used for movie studios. Okay, a smell. You can trademark a particular smell if you created it. Okay, so there are some rights of a color. So Tiffany's has exclusive rights to the Tiffany's color. IBM has exclusive rights to IBM Blue. Those are exclusive uses of a color. Even a hologram, which would include three-dimensional logos, authenticational logos like we have on our credit cards and such, and some pharmaceutical products. So a trademark is a general term, but it's also possible to be more specific. Okay, so like a service mark is a mark used by a business in selling or advertising services. A collective mark is used to indicate that the producer of goods or services is a member of a particular organization or group, such as the International Ladies Garment Workers Union. Okay, so that's the ILGWU. Okay, or the IGA, which is the Independent Grocers Alliance, or FTD. Okay, so that's a collective mark. A certification mark is used as a seal of compliance or approval. Okay, so UL, or Underwriters Laboratory, would be a certification mark. Okay, a trade name is the name used by which the public knows a particular business. A domain name on the internet can be registered as a trademark or a service mark if it identifies the source of goods or services and is not simply a digital address. Okay? All right. There are some restrictions on what can be registered. Okay, so you cannot register a trademark that is confusingly familiar or similar to another mark that is already registered, is a generic term already in common use like soft drink or chocolate bar, is immoral, deceptive, or scandalous, defames an institution, belief, national symbol, living or deceased person, contains the flag or any insignia of a country, state, or municipality, anything that contains the name, portrait, or signature of a living person without his or her written permission, or includes the name, portrait, or signature of a deceased U.S. president during his or her surviving spouse's lifetime without permission. That's an interesting one, huh? All right, so trademark registration. So trademark registration is done through the U.S. Patent and Trademark Office. They are both considered very, very similar things. They both go to the same place, and they are both reviewed by attorneys who determines whether or not something is original or not original. And it can take an exceptionally long period of time. With trademarks, You can trademark for a number of kinds of businesses or a very selective business category. The more categories you cover, the more expensive it gets to trademark. Okay, so Apple Corporation probably owns the trademark in all categories of products and also has an international trademark, which is something entirely different. So, of course, money wasn't an object to them, but that means that somebody can't make Apple candy bars, Apple branded candy bars, because their trademark is, they've covered that category with their particular trademark. Okay? So when it's a fairly simple process to actually turn these forms in, they talk you through them, and then what happens is after a period of time, it could be months and months and months, it could be half a year, you get a notification from a lawyer or somebody from that office who tells you that we've either granted it or we're still thinking about it, but you need to make these changes in order for it to be registered as a trademark. So in my case, when I did Fire Danger Studios, they said, okay, you can do Fire Danger because it's one word, and we have your logo, and that's great, but you can't include studios in your trademark protection because studios is a generic term, ergo it cannot be included. All right? I also included spot colors, which they said you don't include spot colors. It's not a particular Pantone color, just say orange, okay? Because you don't have ownership of any of those particular colors. So you have to use a generic term for a particular color, if all of that makes sense to you, okay? You make those changes and resubmit it. But be aware that you are going to get bombarded by emails from people who just track who's filing what, okay? And they are going to bombard you and try to convince you that you can't do it on your own, that you need their help doing it. And unless you're working for a major corporation, there's no reason to go ahead and hire a full-blown lawyer to make a trademark. Okay, it's really a relatively simple but time-consuming process. Okay, so distinctiveness in the U.S. federal trademarks are placed on either the principal register or the supplemental register at the Patent and Trademark Office. The difference has to do with how distinctive they are. There are 5 different terms used to indicate how distinctive a mark is. Okay, so here I'm gonna go ahead and tell you them from strongest to weakest. Fanciful. A fanciful mark is a coined word that did not exist before and has no meaning apart from the commercial usage. Okay, so what would that be? Kodak. Okay, Exxon, Xerox. Okay, even though it's xerography is the base concept. Okay. Changing the word just enough to still be familiar, but a different word, it didn't exist, is distinctive. Arbitrary. An arbitrary mark uses an ordinary word or phrase in an unsuspecting and surprising way, such as Yahoo, okay, which is a word, okay, or something like a candy bar, O. Henry, okay. O. Henry is a phrase, but it's being used specifically for a candy bar, so that is arbitrary. Then suggestive. These suggest some characteristics or quality of the goods or services, such as a Mustang for a car or Coppertone for a suntan lotion. Okay? Each case, of course, is judged according to its own merits. Okay? Many factors will be used to determine the likelihood of confusion. These are the most important ones. The strength of the plaintiff's mark. The number of existing marks in the same product category. Okay? So is it a crowded field? Similarity of the goods or services. Relatedness of the customers and channels of trade. Evidence of actual confusion. No actual confusion need be found. A likelihood is all that's required. However, actual confusion can sometimes be proven based on consumer polls. So, trademark fair use. Sometimes unauthorized use of a mark will not constitute infringement. In general, courts have recognized the following categories of trademark fair use. Okay, nominative. Okay, nominative. Okay, a non-owner may use a trademark to refer to the actual company, product, or service. Descriptive. If a trademark is descriptive, it can still be used for its primary meaning rather than its secondary meaning, provided there's no likelihood of confusion. Parody. Artists and editorial parodies are a form of criticism, and that is protected under free speech and is allowed. So, defending a trademark. You would, again, in the case of defending a trademark, send a cease and desist letter, okay? Which would be sending a letter explaining the proper use of a mark, okay? This could be a formal cease and desist letter, or it could just be a letter, but you're going to need to send a cease and desist letter, okay? Make a counterfiling with the USPTO, okay, which is the United States Trademark and Patent Office, okay? Objecting to the registration of a trademark and seeking its cancellation. You could negotiate a license, or you could file a lawsuit claiming infringement or delusion. Okay, so trademark delusion. Even when a new mark does not directly infringe on an existing one, there may be an issue of delusion. Infringement is generally focused on products or services that are directly competitive. The question is whether confusion is being created about their source. In contrast, delusion is generally focused on non-competing goods and whether a famous mark is losing its association in the public mind with one particular product or product category. Okay? All right. So, we should probably talk about a few things. I don't know how legal I want to get, because we could spend out. You can have whole courses on legal and ethics and all sorts of other good stuff. But let's go ahead and talk about defamation, privacy, and publicity. Okay, so advertising agencies, publishers, and broadcast companies produce a steady stream of messages for the general public. Okay, the content of these messages often includes information about or images of specific individuals, whether they are models, celebrities, employees, or people on the street. When preparing this content, publishers, broadcasters, and agencies have always been aware of potential liability for claims of defamation of character or violation of an individual's rights of privacy and publicity. It's important to remember the rapid expansion of digital communications means that any company distributing information via email or the web now faces many of those same legal risks. Someone may file a claim against you seeking to impose liability for economic loss or personal injury allegedly caused by some error or negligence in the content of the work that you produce. Personal injury can either be physical or emotional, can include a damaged reputation, okay, and can include a damaged So we're going to talk about the key legal issues that communications professionals have to be aware of. Okay, so defamation. Defamation is the intentional communication of a false statement about somebody to a third party. Okay? Slander. Slander is oral defamation. Defamation. A spoken assertion about someone that is not true. Libel. Untruthful statements expressed in a fixed or permanent medium. Okay, so for an example of that, it could be in writing, on a sign, in a picture, broadcast, radio, television, or the internet. Okay, so this means that the statement has the potential to reach a very wide audience. Okay, defamation per se. Certain types of untrue statements are so serious that they will always qualify as defamation. They are grouped together under the term defamation per se. Each of them is considered capable of having an innocent meaning, such as innocent meanings. Accusations can include inputting that the subject has committed a crime or engaged in criminal conduct, claiming that the subject has a feared illness or loathsome disease, inputting personal conduct or characteristics that render the person unable to perform his or her occupation, such as stating that the person is incompetent or unreliable as a business person, claiming that the subject has engaged in unchaste behavior or immoral acts, such as serious sexual misconduct. Okay? If spoken, these statements are slander per se. If printed or broadcast, they are libel per se. The statement is actionable in itself without the plaintiff introducing additional facts because the harmful intent is obvious. Okay? So claims. When a claim of defamation is made, the following aspects will be examined carefully. Identification. The plaintiff must establish that the alleged defamation refers to him or her specifically. Publication. The statement must be shown to communicated to at least one other person before it is actionable by law. Statement of fact. The statement must be reasonably understood by third parties to purport fact. Falsehood. The statement must be false. Actual injury. In a lawsuit, no one can recover damages unless he or she has suffered injury. Liability. In many instances, whether or not the person who made the statement is found to be liable will depend on whether the injured party is a public figure or a private person. Well, that's open to interpretation. All right. Legal fees. In many instances, a defendant who is found to be liable will be ordered by the court to pay the plaintiff's attorney's fees. Damages. If the defendant is found liable for defamation, the plaintiff will be awarded damages. Privacy. Okay, so the next issue that we're going to talk about needs to be the right of privacy. Okay, and of course this is a morphing thing due to technology, but privacy, interestingly, has less protection in the U.S. than it does overseas. I'm not sure why that is. I imagine it's because corporations want to have access to our information. Okay, so privacy, intrusion. So this refers to an aggressive and shocking intrusion on reasonably expected solitude. Okay, so that would mean entering private property or things like that. Public disclosure of private facts. Okay, false light, which means publicizing information about a person that unreasonably creates an untrue or misleading portrayal. Appropriation and exploitation. This is the use of a person's name, likeness, voice, or other aspects of personal identity without permission for commercial purposes. Publicity. Each person has the exclusive legal right to control and profit from the use of his or her identity, name, image, personality, voice, whatever, to promote and sell goods or services. Appropriation of somebody else's identity without consent violates that person's right to publicity. Okay? My mouth is starting to get a little bit dry here. Okay, so that's a big, broad thing about that. So ethics and social responsibility. In discussing ethics, and in this case design, there are at least 3 different levels for us to consider. The first has to do with professional behavior in daily business interactions. The next level deals with specific professional expertise needed in such areas as accessibility, usability, consumer safety, and environmental practices. This leads us to the third level, which is about overall values, a broader framework of moral principles and obligations in life. So, professional behavior. In your design career, how do you define ethical conduct, and where do you turn for guidance? Ethical guidelines are published in a number of design organizations in the U.S. and abroad. The AIGA. I asked you to buy that book. Okay? That's the Professional Association for Design. The Graphic Artists Guild. I asked you to purchase that book for this class. Industrial Designers Society of America. The Society of Graphic Designers of Canada. The Australian Graphic Design Association, and the International Council of Societies of Industrial Design. Okay? So, through this whole thing, there are some base concepts. Showing respect towards other designers in fair and open competition. Being honest in describing your professional experience and your competencies. Avoiding any type of conflict of interest. Acquainting yourself with each client's business and providing honest and impartial advice. Maintaining the confidentiality of all client information. Eliminating any form of hidden compensation or kickback. Maintaining commitment to the development of innovative work of the very highest quality. Rejecting all forms of plagiarism, and making proper acknowledgement of authorship when others have collaborated with you in creating a design. Okay? Professional expertise. Depending on your design discipline and the nature of your client's business, you may need to be aware of additional responsibilities and legal obligations. Okay? Universal design and accessibility. Okay? Especially in the public domain. Places, products, and services should be universally accessible to people of all ages, abilities, and physical conditions. Okay? That's the ADA compliance. Okay? Consumer product labeling. Okay? If you are involved in the design of certain types of consumer products or packages, you and your client need to be aware of any applicable labeling requirements. Ecology and sustainability. Okay? Each year, issues related to ecology and sustainability become more critical for the entire world. Okay, designers can make a big difference not only through responsible choices about materials and processes used in current projects, but also by staying well informed and providing expert guidance to clients about long-term plans and activities. Okay, values. Clearly, the universal design concerns and ecological responsibilities are part of a much broader system of moral values and obligations. Okay? The expansion of consumer culture is critical. Designers are involved in many different activities, but a significant portion of the work that we do promotes corporate commercialism. Unfortunately, that is a necessary evil. Okay? We are creatures of a consumer society and a consumer culture. That's what graphic design is really all about. And you have to make that moral understanding. You have to come to that moral understanding. Okay? Increasing the power of corporations. Most leading design firms work for large corporate clients, and it's no secret that good design sometimes supports bad companies. Globalization. Many designers work with multinational corporations, either as outside consultants or in-house employees. So what's the designer's role? The designer is design is a problem-solving process, and the world today has plenty of problems. Designers need to play a larger role, not just in responding, but initiating. We need to bring our personal beliefs and professional activities into alignment. Through our work, we have the opportunity and responsibility to put our system of basic values into action to model the behavior that we want to see in the world. Okay. So I hope that gives you a good, brief kind of overview. Really, it's about respect. Really, it's about knowing when to call a lawyer, being well informed about what you're trying to do. So I hope this lecture has been helpful to you in understanding trademark copyright and some of the ethics issues. But again, I have given you reading assignments in the AIGA book. The Graphic Artists Guild book is more of a reference and a starting point for forms and all sorts of other good stuff. But it does have many sections on ethics and our responsibilities as designers and or illustrators. All right, bye.